Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi taala wabarakatuh. Assalamualaikum.
Waalaikumsalam warahmatullahi wabarakatuh.
Can you hear me?
Yeah.
Let's start our class with the recitation of Untitled Chapter. Okay, welcome back to the school. I hope you are doing fine. You and family are doing all right. So I will be teaching you Law of Torts this semester, Law of Torts 1, LAC 2053. Law of Torts 1. All right. So, okay. So today is our introductory lecture where I will introduce you the course and also brief you on the assessment of the course. So if you have any questions, you can either unmute yourself or put your questions or queries in the chat box. I think there are quite just hold on. 32 people are here. Ada lagi yang request ni. How are you guys? How are you doing are you in your hometown now? Or are you back in Nilai somehow?
At hometown.
At home, doctor.
Right.
At home.
So have you had your lunch?
Yes.
Yes.
Alhamdulillah. It's a challenging time, especially in the afternoon. So first of all, I would like to request the class to change the profile picture with your face picture, so that I will be able to recognize your face throughout the semester. I would like to speak to human, not to anonymous. Yeah. So if you don't do it today, please do it as soon as possible. Not yet. Okay. So you should take your lunch soon. Maybe you have a heavy breakfast, I guess, in the morning. So whatever it is, make sure don't forget your meal. So today, as I told you just now, I'm going to introduce you to the course first before we go into the topic on what is torts. Okay. So for the first part of the lecture today on the course briefing, I will give you a bit of explanation on the use of problem-based learning. Have you heard about problem-based learning before? You might be familiar with problem questions, right? When you do tutorial activities or answer your mid-semester test or doing your assignment. Okay, so problem-based learning, basically I will conduct the lecture and tutorial using problems. You might be familiar with using problems in tutorial or in answering exam, but this might be your first time in using problem during lecture. So that's what I will do this semester. I will explain about it later. And secondly, we're going to look into the teaching strategy, the assessment strategy. So since we are still online, the assessment would be 60% for the carry mark for the continuous assessment and 40% for the final exam. Right. And then I will also touch on the tutorial activities and finally the course references. what are the texts or the books that you need to have, and what are the other things that you need to focus on, especially on the case laws, right? So this is what we call as problem-based learning. So normally, by tradition, when you go to lecture, so you just prepare yourself, sit down, and being told about what you are going to be taught on that particular day, right? So the lecture, we come up with the outline, what are the things that will be covered for that topic, and then you memorize, and then you'll be given problem later after you have finished the lecture for that topic. So that goes on and on after you've I mean, that's basically the method on how what we call traditional learning. But this semester, for this subject, I'm going to change a bit the method, where I will start the class by sharing you a problem, okay? A problem that I take partly from the past tutorial questions and also the exam questions. So based on the problem, we will identify together what are the issues based on the problem. So basically, I will start with the problem, and then I will give you the explanation, what is the related legal concept, legal principle, and cases. And then in the meanwhile, we will go through the problems together during the lecture and apply and solve the problems during the lecture. The reason why I decide to carry out problem-based learning, students always have difficulties to understand and also attempt to answer problem questions, right? And I'm not sure, but this might be the general impression. Some students, I don't say many, I don't want to say many, but some students do not like to answer problem questions. For this subject, I will use very minimal essay questions. That means your exam questions, your tutorial, and including your lecture now, you will deal a lot with problems. So we start with the problem so that students are able to understand on how to attempt, sometimes how to attempt a problem questions. Students, you have no problem when it comes to memorizing the case laws, right? But when it comes to the application, sometimes students stuck on how or when the case would be relevant, where the case would be relevant in answering problem questions. Okay. So as I mentioned to you during the lecture, I will use a problem or a scenario to help you understand the topic. The flow will be like this. I will start with a problem. For instance, next week we will be doing on trespass to the person. So I will start with a problem or scenario on trespass to the person, and then I will explain the elements of trespass. And in the meanwhile, you will see a box, a green box, where I put a pause for reflections, where you will relate the law to the problems. So that means I need interaction during lectures. It's not like one-way communication. My lecture would not be for 2 hours. I try to make it as concise as possible so that you will have time to read the case laws. In other words, I would not spend time explaining the case laws because the time on reading the case laws will be on your part. So what I'll be doing is that I will focus on the landmark cases so that can give you some guide on what are the principles coming from the case law. And my focus is I want my students to understand on how to relate and apply the problem to the topic or to the issue of law. So that's the lecture. In terms of the assessment strategy, so basically for this course, we have 3 course learning outcome. I did not write it there. So basically the first outcome is to apply, at the end of the course you will be able to apply relevant principles of the law of torts relating to intentional torts and unintentional torts. So when I say what we call it, intentional torts, that refer to trespass. Okay. Secondly, we will also discuss on unintentional torts, which refer to negligence. So we explain to you later about unintentional and intentional torts. For CLO2, from this course, you'll be able to compare different types of course of action to solve a given problem. So for instance, in trespass, you need to prove a certain element, that there must be a direct, intentional and unjustified contact between the plaintiff and the defendant. And in negligence, you have duty of care, breach of duty, and the remoteness of damage. Okay. So different cause of action have different elements to be proven by the plaintiff. And in the meantime, we also look at what the how the defendant can counter argue, meaning that once the plaintiff has made out his case, then what the defendant should do to counter the case against the plaintiff. For the third course learning outcome is that we're gonna look into the remedies, the remedies available for the tortious course of action. So for the first CLO, the first course learning outcome, this will be covered in your mid-semester test. The assessment will be through mid-semester test and the final exam. So if you have the chance, or if not, you can do that later. You can have a look at the course detail, the course outline, and also the course teaching plan on goals. I have uploaded the material on goals, so please have a look at it later. So this all together will give you 50 marks, and the question will come from the topic on trespass. So, but the final exam will cover quite a few topics other than trespass. But for your mid-semester test, that will cover the topic on trespass only. So if you see in your course teaching plan, the mid-semester test will be done in November. So it's about 1 month to go. Yeah. Right. And then for the course learning outcome number 2, this is what I'll be doing this semester. That I give you a problem-based questions. It's a big questions that I will give you a bit by bit. So the assignments here we have in group and also individuals, and also presentation. So don't worry, I will not like lump in every or all informations today. I will give you a bit by bit so that you can follow the flow of the course. So this under CLO2 will give you 40% of the detail. I will provide you when the time comes, or when we get closer to the times. So you can just refer to the course teaching plan. I will alert you when the time gets closer to it. All right. For the third course learning outcome, you will have the third assignment. Since you have the third assignment, which gives you 10%, this is going to be your group work, where the course learning outcome here for the third assessment will be done with a legal practitioner. So you will have a session with a lawyer who will give you a talk on how to prepare a statement of claim. Statement of claim is like how the plaintiff can prepare a good case based on the problems. and then this will be, and then you need to prepare the statement of claim and will be assessed by the legal practitioners. Any questions so far from the class regarding the assessment? So for course learning outcome number 2, the topic covered will be on negligence and damages. Alright, so negligence, we have general negligence and also specific negligence. Specific negligence means professional and medical negligence. General negligence will involve negligence like accident. Yeah, professional negligence involve engineer, involve architect, or involve contractor, or involve a banker. So that considered as professional negligence. Even lawyers, okay, considered as under professional negligence. Medical negligence obviously involve medical officer or medical doctors, right? On damages, so on negligence basically will be covered for your assignment number 1 and number 2. For damages, will be covered under assignment number 2. So there will be maybe 2 to 3 questions for assignment number 2. So that would be your individual task. All right. Any questions so far from the class? So I hope that you are clear about the assessment type here, and please make sure you understand and do not miss out the deadlines given to you. The deadline is already provided in the course teaching plan, so please have a look and pay attention to it. All right, in tutorials that we do it weekly, I will give you the tutorial questions that will be distributed on course. The tutorial we start next week. All right, and a related point to this, in tutorial, you have about 12 to 15 people in tutorials. So I need you to divide the in your group 3 law firms. Yeah, so you will have about 4 to 5 people in one law firms. So regarding the law firms, you have the right to choose who would like to be or who would like to join your law firm. So you create like your own law firm. So whenever you have presentation session during tutorial, you're not going to present every week. So there will be alternate presentation. So that's why I will come up with a schedule of presentation later. But at the moment, it's for you to create the law firms. So you decide among yourself who would like to join each other. Right, and then create the name of law firms. And the presentation by law firms will be done through client counseling. Have you done client counseling before in other courses, in other subjects? No? All right. So this is something new as well for you. Never mind. I will give inputs before we carry out client counseling. Client counseling is basically like an acting session where the client will come to your office, the lawyer's office, and then we share the problems that you need to give advice to your clients. Okay. So I will give you more details on this later. Well, apart from client counseling, we will also have like a normal or regular presentation like what you have done in other subjects as well. That might include as well in terms of the case review. We will select several cases for discussion during lecture, during tutorial. So this is what I told you just now. You need to create 3 law firms, so you decide among yourself. And then the question inshallah will be uploaded on Go somewhere around this week, latest by Thursday. So for the course references, the basic text will be by Prof. Said Ahmad Al-Asagov, the books on law of torts in Malaysia, and also Jolowicz on torts. But don't worry if you do not have the text with you at the moment, because the most important thing is to read the case laws. But if you want to buy the text, I can contact Prof. Arsagov to get a student price. Just let me know. Maybe I can collect the names and submit to him, and then the book will be sent to your mailing or home address. So case laws, because torts basically is a common law subject. So we will deal a lot with the case laws, either English case law or Malaysian case laws. Right, apart from the text, apart from the case laws, we will also refer to a statute, maybe a few other statutes as well, but this is the main one, which is the Civil Law Act 1956. I believe you are familiar with the name of the statutes, right? Because you have done Malaysian legal systems, you have covered section 3, section 5, and also section 6 on the reception of English law in Malaysia. For this subject, we will use this statute on the topic damages. Yeah. So you don't need to buy the statute, you can just download. Actually, I have the copy, but because all materials are available on my Teams channel for the last Torts 1, so I can share with you. It's just that on Teams, I will just use for the lecture. For the course material will be available on Go, but I will transfer the course information gradually, inshallah. And finally, this is an important reminder. My lecture slide will be quite brief this semester because I will focus more on discussion of the problems and some landmark cases. But if you would like to have a complete notes, I can just share with you based on the previous semester. Nothing much different, but this semester I will change, not to say a lot, but I will tune the content of the lecture note based on my teaching approach this semester. Content wise is the same, just the approach is different. So the lecture slide, as I mentioned here, is just a guide. That means when you have a complete lecture notes, if you want later, that does not mean that you do not read the cases. The cases you still need to read for reference, because that's the main authorities, the main legal authorities when it comes to studying torts. Right, any questions before I start the lecture? Okay, I guess no question yet. So this week, introductory lecture, I will introduce you to what is torts, why we learn torts, apart from, of course, in your curriculum. Whenever you first time you come to the law of torts class, then that should be, you must be wondering why you should learn law of torts. Why would torts be relevant for you as a future practicing lawyer or as a future legal practitioners? Or if you're not a legal practitioner, what would be relevant to law students to learn torts? Okay, and then we're going to look into the sources of law of torts, and finally, thirdly, we're going to look into the classification on the law of torts, and finally the distinction of torts and other areas of law. Right, so torts is basically a civil wrong. A civil wrong, when we say a civil wrong, is a private actions against between individuals. So when I say wrong, then that would involve infringement or breach of some legal duties or obligations. A simple example would be like an accident. Okay, when A and X, A is driving a car and A knocks down B. Okay, A and B is involved in a collision, a car accident or vehicle accident. So that is considered as civil wrong. But then here the issue is, can a tort be a criminal wrong? Can a tort be a crime? You know, I think you have maybe come across before under your subject of Malaysian legal system on the classification of law. You have public and private law, right? So private law normally torts is under the category of private law. But then I have a question for you. Can a tort be a criminal or a public law? Can a tort be a criminal wrong?
Can I try to answer, Doctor?
Yeah, please. How should I call you? Mustafa, yeah, please go ahead.
As far as I know that an action to be considered as crime in Malaysia, it must be stated in the penal code to be considered as crime. And tort is an action that an exception towards the civil law. Therefore, I think a tort cannot be a criminal, but it can be a civil wrong.
Okay, thank you, Mustafa, for your opinion. Can I hear any other opinions? Do you agree, Mustafa, or you have any other alternative opinion?
May
Okay.
I try, Doctor?
Yeah, sure, please. Go ahead. Your
The
name?
noise. My house is currently under. My name Aziani.
Aziani, yeah.
Okay. In my opinion, a tort cannot be a criminal wrong, as criminal wrong will involve public, but tort only involve individual.
Okay. All right. Thank you, Aziani. Let's extend my example just now. A and B are involved in a car accident. So it's an accident basically is a tort. Okay. What if B B is dead because of the accident? Can it still be under tort, or it would become a crime now? Okay, that's one example. Another example is in a tort. Okay, let's take a close. Maybe this example would be quite familiar to you. The case of Sungai Kim Kim. Do you follow the case closely?
Not so close, but we are aware of the incident.
Right. So you know that in that case there was a river pollution, right? In Sungai Kim Kim. The case was considered under nuisance, but the case was categorized as a crime rather than a tort. So nuisance falls under tort because nuisance, when it happens between individuals, nuisance is like when there is a pollution, it can cause bad smells, it can cause people who get infected by the polluted water, they can get some disease or unnecessary allergy because of the pollution, because the water is a source of natural resource for human living, right? Nuisance is a tort, but nuisance also can be a crime because it can become any torts can become a crime when it does not only affect individuals, but it also affects the society. Not necessarily need to be all society get involved, but at least you can form a public, like, you know, in a kampung, for instance, yeah, where some people got affected by the water or by the river pollution. So you can actually take action against the perpetrator under crime. So you have like a double-edged sword, meaning that in that case, Sungai Kim, you can take action under public nuisance. So the initiator for the case would be the public prosecutor against the perpetrator, the company who has polluted the river. So when that happened, that would be a public nuisance, and that would be a case for a criminal prosecution, not under tort. But if you are the only one, if you are the only individual, maybe only your family get affected by the pollution, then your action will be under torts, because it's a private actions against private individual or even against a company. So it can be a crime. It can be a crime when the affected or the victim of the wrong involve the public, involve more than individuals. I hope you get the message.
Yes.
Right.
Yes, doctor.
So that happens quite a lot. I mean in Selangor we have many like water. Suddenly you have a water shortage, right? Water breakdown. So Jabatan Alam Sekitar can take action against the company for polluting the river under crime, not under tort, because it's a public nuisance. You have seen many cases in Selangor, particularly when the company release a dangerous emission of pollutants or chemicals into the river. Syabas will have to stop the water flow from the dam for the public consumption. So the company in that case can be sued for a criminal wrong for public nuisance, because that affects the people in Selangor. Millions of people in Selangor. So that would fall under public nuisance. Public nuisance is considered as a crime. If it is a private nuisance, then it will fall under tort. So taking back the example of accident just now, so it can be a tort when it does not involve, when no life is jeopardized, when no life is involved. If B is dead, it can be a crime. You can sue B under causing death, or what we call as homicide. Or A does not have intention to kill B, right? But because of the accident, because of his dangerous way of driving, he can be charged under culpable homicide under the penal code. Well, we have seen this example a lot when it involves drunken driver. Yeah, they are under influence of alcohol or drug, for instance. So in that case, they can be charged under the penal code or under the Road Traffic Act, where the public prosecutor will take action against the driver. But if it does not involve any loss of life, then you can take action under torts. So there is a division line there, when you can take action under tort, when you can take action under under crime. If you are also familiar with the case of the late Ardit, who has been beaten up by his colleagues in UPNM. So it can be a tort, but in that case it was charged under crime because it has caused the death of the late Ardit. Are you familiar with that case? Do you read newspaper?
I'm sorry, doctor. You said Adib UPNM.
Yeah.
If I'm not mistaken, UPNM is Farhan.
Farhan.
Yeah.
Farhan or Ardit, because Ardit I know is a different case. Okay, at least someone is alert on my example. All right. So in that case, if no one is like no one is died, then most probably the action will be taken under tort. But since it involves death, and this also a case of murder, so the appropriate action would be under crime, that the perpetrator, the suspect, were charged under the penal code. So why we learn torts? Basically is to ask the other person to pay for compensation for the harm that the defendant has committed or has wrongfully committed, right? Okay. And apart from that, torts also allow the court to stop or regulate a certain conduct. For instance, in the case of trespass. In the case of trespass, if, for instance, someone go into your house without your permission, you can charge them under trespass. If there's still any valuable items in your house, you can charge them as well under trespass, but particularly under trespass to goods. If there is any loss of valuable items, then you can claim for compensation for that, right? And if like you are being continuously disturbed by someone, you can sue them under trespass as well. So by the order of court, you can apply for injunction to stop the person from continuously harassing me or trespassing your privacy, or your privacy. So that is the purpose why we learn torts, compensation primarily. Yeah. So you want to claim for compensation for the act that a defendant has wrongfully caused to the plaintiff. Okay, in terms of the sources of law in torts, so technically we know that torts is a common law subject. So when I say it's a common law subject, the principles of the law of torts mostly comes from the case laws. So that's why we read case laws in torts a lot as compared to other subjects. For instance, if you learn contract, then you will refer a lot to the Contract Acts. Of course, they have cases as well, but your main preference will be the Contract Act. But in torts, the principle will come mostly from the case laws. So the principle here is made by the judges, not by the legislature. There are some law of torts principle coming from the law, but still in terms of proving the case, you need to refer to the case laws. And apart from the English common law, we also have the local court's decision or precedents, and also statutes. So on the application of English law in Malaysia, we need to refer to the Civil Law Act Section 3, Subsection 1, where this section explains about the reception of English common law, equity, and other statutes. So in the statute here, you have the courts in Malaysia shall apply English law according to the cut-off dates. That means if the case laws were decided before 1956, then English law would be binding upon Malaysian courts. But after that date, the English authorities, English case laws would be persuasive for the Malaysian courts to follow. But then there is a question, to what extent in torts Malaysian courts should follow English tort law? Because as I mentioned to you just now, in Malaysian tort law, we rely a lot on English torts. We rely a lot on English cases. We do have some cases, we do have some Malaysian court decisions. If we have a Malaysian court decision, then you need to follow the Malaysian court decisions. If there is any lacuna in our law, we need to refer to English law. So the following cases will tell us that to what extent Malaysian court should follow English law. So basically, English law applies in all torts or tortious dispute, unless if the law is not suitable for the local circumstances. There are some areas that we will go into that in details later, that the position in Malaysia on certain area of torts is different from the English law. But for now, it's enough for you to understand that English law is applicable in tortious dispute in Malaysia. For instance, in the case of Nepline, in this case, the court held that the lawyers always refer to English case laws as if English case law is the contemporary law in Malaysia. That means English law is fully applied in Malaysia. In some other cases like Jamil Harun, in this case, the court agreed that English authorities has influence in Malaysia, but it is up to the court to decide whether they would like to apply or not English law. If the court applies English law in the Malaysian courts, then it must be permitted by the written law, by the statute, and it is justified, it is fair to do so. So when we say only to the extent that the written law permits, that means some statutes, they are very comprehensive, so that you do not need to refer to English law anymore. In other words, you need to refer to the statutes and the Malaysian cases only. Jamil Harun involved a case of accident, yeah, and it is also fair to do so. That means, because you must understand, the local circumstances may be different in some cases, so that the court can decide not to follow English law if it is unfair to follow the English law. So this is actually the basic principle, not only in torts. You may have come across this case before, right? If I'm not mistaken, in your reception of English law topic in your first year. Have you come across with this case before? Pernah tak baca case ni? Tak pernah?
Pernah.
Pernah, okay. So this is the principle from Jamil Harun. Another case is Sri Inai. Sri Inai is an international school in Penang. So in the court's opinion, that the court will apply English common law or English law regardless of the cut-off dates. So there are certain cut-off dates, right, in Semenanjung, Sabah and Sarawak. So regardless of cut-off dates, in the law, in the tortious dispute, the court will just ignore the cut-off dates. So that means if there is any lacuna in the Malaysian law, the court will rely a lot on English law because they are more advanced when it comes to English law, when it comes to torts law. Right. But there are some decisions where Malaysian court has decided and we need to follow. For instance, the federal court has decided on certain issues which is different from the English courts, then you need to refer to the federal court decision, or the highest court decision could be from the Court of Appeal. If it's just a high court decision, then that means not strong enough. But if the highest court decision coming from the Court of Appeal or federal court, that means the Malaysian court needs to follow the Court of Appeal or federal court decisions, even though you have the House of Lords or Privy Council decision in England. It does not really matter, because you need to give preference over the Malaysian local court decisions. About the case laws, Malaysian court normally follow, Malaysian court do not follow English law if it is absurd for the local circumstances. So this is what actually an explanation that given to you before. So in the case of Majlis Perbandaran Ampang Jaya and Stephen Phua Chen Lun, in this case the court do not see why English law cannot be applied in Malaysia. Unless if it is unfair, then the court will not apply in Malaysia. So the basic rule, the baseline is that the courts in Malaysia will apply English law if it is relevant, if it is fair to do so. If it is not fair, then you do not apply English law. So you must make sure that first, when you rely on English cases, you must understand whether the facts of the case in Malaysian case would be similar. Would the court be fair or unfair when the court refer to English precedents? If the answer is when the court rely there is no problems with the fairness, then the court will just follow. The court can just follow English law. But if by following the English court decisions, that would cause unfairness or unreasonableness to the parties for the Malaysian case, for the Malaysian dispute, then the court can decide not to follow, or the court can refuse to follow the English court decision. So if you have gone across before on the topic of stare decisis, this is the same principle that we apply here. This is another important principle coming from the case of Syarikat Batu Sinar Sdn Berhad, where the court said that we cannot simply accept English common law. When you apply English law, you must make sure, the court must make sure that it must be fit for the local people, for the local condition. Okay. So the court can refer, but the court need to deliberate whether it is fair or not to do so. So as a lawyer, you do not simply it's not like playing a jigsaw puzzle just to fill in the gap, but to make sure that when you refer to English cases, then it must be suitable with the local circumstances. Right. The original form of English law, of tort law, is based on case laws, based on common law. So as you know that common law is unwritten, right? It started with customs or tradition, right? But over the years, case laws are reported and they are put in the law reports. Okay. And over the years as well, some of the common law principles are legislated or codified. That means some principle, for instance, like in the case of defamation, defamation is a common law action. That means if you want to prove a case on defamation, you will need to rely on to prove your case based on the case laws, based on the principles decided by the judges, based on the precedents. All right. In Malaysia, we have introduced the Defamation Act 1957. You will learn this next semester on defamation. So the people, the plaintiff who bring the case to court on defamation, they have to refer first to the provision under the Defamation Act. Then for instance, to prove whether a particular word is defamatory or not. So you need to refer to which section under the Defamation Act. To prove on the defamatory word, for instance, you need to refer to the case law. So the case law can come from the Malaysian case law or English case law. In other words, when there is a statute will be your first reference. And to support your case, to support your claim, you refer to the case laws. But not all cause of action will be covered under statutes. Only certain actions will be covered under statutes. So when you have statutes, that means the principle has been codified. For instance, like in the case of defamation, in the case of public nuisance, for instance, that falls under the Government Proceeding Act 1976. But generally speaking, when you talk about torts, when you talk about torts, generally it is not provided in the statute. Some other action, for instance, about passing off Passing off is under IP, under trademark. Yeah? For instance, when shop A and shop B, now you have like McDonald. Yeah, McDonald actually, this is the actual case where McDonald brought a case against. Actually, it's a Malaysian company. It's a Malaysian restaurant in Keramat. So they have a shop name similar to McDonald, so that you can bring McDonald can bring action under passing off. Passing off is actually a common law action where you can sue under Trademark Act, and you can also bring the relevant common law principle from the case laws to bring your case under passing off. So that is to tell you that in some cause of action, in some causes of action, your action, you need to check whether there is a particular statute covering that particular cause of action. So you need to refer to the statute first and then followed by the case laws. If there is no statute, then you can just rely on the principles of the common law. When I say principle of the common law, I'm referring to the case laws. Right. How do we prove a case in tortious action? So it can come in two ways. Number one is acts or omission. So in torts, basically, the plaintiff must prove that the defendant's act or omission has caused the damage, must lead to the damage. So the act must be a positive tortious act. In the case of trespass, for instance, you must prove that the defendant has entered into your place, into your premise, into your house, for instance, yeah, into your house without your consent or without without any authorization. Okay. In torts, you can also bring an action if the defendant has omitted to do something, but the omission must be a pure or a real one. So mere omission is not enough. For instance, like in the case of accident, just because you're not pressing brakes, that's not alone enough to be an actionable tort. You must prove that because of the failure to pressing brake, then the defendant has failed to exercise care and skill to avoid the accident. So the failure here is under negligence. Failure to do something where, as a road user, you are supposed to be like other road user, meaning that you have to drive your car safely and not causing danger to other road users, right? But in the case of negligence, sometimes because we do not do that, that cause damage or accident to other road users. For instance, we are not supposed to speed at a particular area, but we overspeed, for instance. Okay, that is a tortious act, right? But not pressing brake is considered as omission. But not pressing brake alone is not enough. It must lead to the cause of the accident, meaning that the failure of not pressing brake has caused the defendant failure to control the car and cause damage or cause accident to the other road user. Right. If the defendant's omission, can you understand that part? Any questions so far? No questions? Okay. If omission also can happen, but this omission is omission can happen when the harm is done by a third party. For instance, here a nurse is under the supervision of a doctor. So a doctor normally will, a nurse normally will assist the doctor in treating the patient, because most of the time, doctor will just, visit the patient at only certain period. Most of the time, of the patient will be spent with the nurse. So the doctor gives instruction to the nurse, for instance, to give medication to the patient at certain hours, to monitor the progress of the patient, right? So what would happen if the nurse has given the wrong treatment or has given the wrong medication to the patient, and the patient has got paralyzed or has got allergy, for instance, because of the Nurse Act? Would the doctor be liable or not for that? So here the omission the omission is when the omission happen when the harm is the tortfeasor. Here the tortfeasor is someone who did the act. Yeah, so here the nurse is considered as the tortfeasor, but the question here is, would the doctor be liable for the nurse fault? So if you understand, we'll discuss this later on vicarious liability. The nurse is under the supervision of the doctor. So the defendant's omission here, refers to the doctor's omission to prevent harm. That means the nurse is under the supervision of the doctor. The doctor's failure to monitor the nurse action can be considered as a negligence on the part of the doctor, and that has caused the damage to the patient, which the patient has suffered paralysis or serious allergy, which require him or her to go for a serious surgery, for instance, yeah, or has caused serious loss on his or her eye, or any effect on the organ of the patient, the organ of the patient. So in this case, under the rule of vicarious liability or non-delegable duty, the doctor can still be liable for the fault done by the tortfeasor, for the fault done by the nurse. The same. Okay, that's one example. Can you understand that example? So here there needs to have an additional legal requirement. So normally you know that the tortfeasor in torts, the tortfeasor will be liable for his own or her own act. If you do something wrong, you will be responsible for your own act, right? But in some other cases, the tortfeasor, the person who commit the tort, we call it tortfeasor, yeah, would not be on the tortfeasor would not be the only one who would be liable for the fault. There can be somebody else also be liable for the act. So in this case, when the nurse is as a tortfeasor has committed the wrong, the doctor, in fact the hospital also, will be jointly or vicariously liable for the fault by the nurse, because the nurse is under the supervision of the higher authority like doctor or the hospital. Right. Any questions? Do you understand? Can you understand the example I share with you?
Yes, doctor.
All right, alhamdulillah. Okay, next, state of mind. Okay, so first, in proving a case in tort, you must prove either there is an act or omission. If an act is much easier to prove, because you prove that defendant has done something, like in trespass, defendant has touched you physically without your consent. If you consent to that, there's not a trespass, right? And there can be also an omission. Omission cannot be just a mere omission, but omission when it leads to the damage, then can only be a cause of action in tort. So, okay, so that is under category 1. Category 2, state of mind. State of mind is basically we're talking about intention, right? In torts, it is basically based on fault-based doctrine, meaning that in tort, particularly in the case, I'm talking about the case of negligence here. Yeah, fault-based doctrine is under negligence. So in negligence, okay, let's take the example of a different example of an architect. You You bought a house, okay? You bought a house and everything is okay, but after you have paid for the house and then after 10 months you have occupied the house, you suffer a serious defect in the house. And the defect was not informed to you when the key is handed over. So here, you can sue the architect and the Majlis Perbandaran for the failure to ensure that the house is safe for stay. So here, when there is a fault-based doctrine, the defendant, the Majlis Perbandaran or the architect or the developer here, not the developer, to sue the architect will be quite remote, yeah, because in tort you can, of course, if you go to court you can sue everyone, but it's either there are suitable party or not. That's a different case. So in negligence, basically what the plaintiff must prove that the damage that the plaintiff has suffered is or must be caused by the act of the defendant. So you must prove, in other words, the causation. You must prove there is a correlation between the failure of the defendant, the developer, the contractor to ensure safety has caused damage to the house. Okay, so that's what we call as causation lah, where you need to prove the correlation between the two parts, the act of the defendant and the damage that the plaintiff has suffered. In tort, the reason why we learn tort, as I mentioned, because of we want to claim compensation. So we assume that when we claim for compensation, as if the tort or negligence had never been committed, meaning that we would like to claim for compensation to restore the position to its original position. For instance, in the case of negligence just now, you claim for compensation so that the developer and the contractor repair the house according to the agreement. So that means as if there is no leakage, there is no defect in the premise. That is an example under professional negligence lah. All right. Maybe I can take another example under trespass to land. Your father owned a piece of land, like 1 acre, for instance, yeah, but it was abandoned. It is an abandoned or deserted area, piece of land. So one day, you find out that the land has been taken by a developer, and they built a structure, a concrete structure on the land without the knowledge. You found that this is considered as a trespass because the developer never seek your consent or permission to use the land. They never. Normally, developer can take over the land, right? Either they pay you a compensation as a reward or as an exchange for the land. But in this case, the developer never asked the owner about the land. They just built the structure without the consent, assuming that because the land has been abandoned for a while, so they assume that no one, the land does not belong to anyone. So they have built the structure on the land, a concrete structure, like say for instance, like a shop lot, yeah. So that you can bring an action under trespass to land, and you can claim for compensation because the land, if you want it can be either two options. If you want the building to remain there, you can still claim under trespass. But if you don't want the land, the building to be there, the concrete structure has to be removed. So that can cause damage to the land. So the developer has to pay the compensation as if no trespass had been done by the developer before. So when you claim for compensation, your aim is to restore the land to its original position, as if no trespass has been committed by the developer. So it does not really matter whether, well, sometimes they build concrete structure, sometimes they use the land, because no one actually care about the land, right? Maybe the land is quite far away from our place, so the land just being abandoned, and that sometimes they plant something on it, like like a garden or like a plantation without our knowledge. So that is still considered as a trespass. Yeah, so you can claim for compensation for the trespass if it has caused damage to the land, when as if the trespass has never been committed by the defendant. Boleh faham tak? Any question? Alright, so here when we talk about fault-based doctrine is when failure of the defendant to act according to the legal duty obligation is under negligence. So for that, for trespass is slightly different, because you claim for compensation as if the act has never been committed. So trespass, either trespass to the person, trespass to land can be the example. Let's take the example of trespass to the person. You have been hit by someone who maybe asked you for something but you refuse to cooperate. So you got punched by the defendant and that left bruise on your face, and you lost your teeth, for instance. So you have to undergo medical operation or surgery because of that. So you can ask for the compensation for the replacement of teeth, equivalent equivalent number of teeth that you have lost, as if you have never been trespassed, you have never been hit or punched by the defendant before. So when you claim for compensation, you want to restore the position, you want to restore the matter to its original position, as if the matter has never been committed. All right. So apart from that, the fault liability may be diluted. So basically, when the tortfeasor has committed a tort, so he would be liable, she would be liable to pay compensation to you as the plaintiff. But in some other circumstances, the fault or liability can be diluted by insurance. For instance, in the case of accident, all right, when your car is covered by the insurance, so you can actually use the insurance to pay as compensation to recover compensation for the damage suffered by the other party. We call it NCD lah. For instance, you send the car to the workshop, and then the insurance, the compensation can be paid by the insurance company. So not you paying, not the tortfeasor paying for the compensation, but because the matter is covered by the insurance company, so the insurance company will take care of it because it's already covered by the insurance coverage. Or in some other cases, in the case of vicarious liability. So in the case of just now I shared with you about the nurse is the tortfeasor. So generally speaking, basically speaking, the nurse should be liable to pay the compensation, right? Because she has committed the fault. She has caused the damage directly to the patient. But in vicarious liability, the liability of the tortfeasor can shift from the tortfeasor to the employer. So who is the employer, or to the supervisor? So it could shift from the nurse to the doctor and also the hospital. That's why if you see the cases of medical negligence, they sue the hospital because, for instance, their claim for for instance, the nurse has wrongfully transfused the blood to the patient and has caused HIV infection on the patient. and the patient claim for 1 million, the nurse will not be able to do that. If the nurse will go bankrupt, right? So normally the plaintiff will go after the hospital because the hospital is able to pay the compensation of that amount. So here you can see that the liability has shifted from the tortfeasor to the hospital, to the institution itself. Right? Boleh faham? So the general principle, the fault, if it is done by the tortfeasor will be liable. But there is always, that's the general rule. There is always exception to that. That means if you have insurance covered for the damage, if you work for an institution, then that would fall under vicarious liability, where the institution, the hospital in that respect, would be liable to pay more compensation to the plaintiff. All right, intention. So intention, to prove intention, it works differently in tort. It depends whether it is intentional torts or unintentional torts. So intentional torts mean here, like in the case of trespass. In the case of trespass, when you say intention, you do not, as the plaintiff, you do not need to prove that the plaintiff has bad intention towards you to cause damage to you. Meaning that, for instance, the plaintiff is jealous with you, so you do not need to prove about on the jealousy, on the bad motive of the defendant. There is no need to prove on that, and the court will not entertain if that's your cause of action, unless if it is a case of malicious prosecution, where the plaintiff maliciously want to prosecute you in court, and there you can bring under malicious prosecution, or like in the case of conspiracy or misfeasance of public office, when the plaintiff, when the defendant use his position to commit torts against the plaintiff. In that case, in that two cases, you can prove the mala fide, the bad motive. But generally, in some other torts like trespass, you do not. That's not what intention means. It's enough to prove that when there is a what we call it, there is unjustified contact between the plaintiff and defendant, and you do not agree to that. So that is enough for you to bring your case under trespass. In fact, under trespass, you do not need to prove damage, because damage is not necessary to, physical damage is not necessary to to be proven under intentional torts. But in the case of unintentional torts, you also do not need to prove intention. In the case of intentional torts, intention here means intention to cause harm. So you do not need to go further by saying that defendant has bad motive. In the case of unintentional torts, you do not need to prove an intention at all. For instance, in the case of negligence, just now we're talking about medical negligence, when the nurse has committed, the nurse has transfused the blood wrongfully to you as a patient and caused, not to you lah kan, to X, for instance, and suffer, him or her get HIV, get infected with HIV. As the plaintiff, you do not need to prove that the hospital has bad intention or whatsoever. In the case of unintentional torts, what you need to prove is that whenever it case of negligence or strict liability, what do you need to prove is that the defendant has failed, that's the key word here, failed to exercise reasonable care to prevent harm to the plaintiff. So in negligence, you have the hospital or the doctor has a duty of care to make sure that the treatment is safe for the patient. If any procedure they would like to carry out, they must be safe for the patient, and they follow the medical standards, right? So in the case of unintentional torts like negligence, as the plaintiff, you must prove that the defendant has failed to do so and has caused harm to you. So the standard of care here is determined by the profession. If you are a doctor, then you need to follow the medical standard, the medical standard of the medical profession, and etc. etc. Like if you are a road user, like in the case of accident just now, so the standard of care would be what would be the road user in the same situation? Would they press the brake? Would they overspeed or not in that situation? So in unintentional torts, the plaintiff must prove that the defendant has failed to exercise. If you're talking about road user, the defendant has failed to exercise care and skill as a reasonable road user. If a doctor, as a reasonable doctor. So there is no need to prove intention, but instead prove that the defendant has failed to prove to exercise reasonable care to prevent harm. Right. Next, on the distinction of torts and other categories of law. Any questions from the class? You can raise your hand or you can put in the chat if you want. Right, torts and crime. So as you know, torts generally is a private wrong. Crime is a public wrong. Torts can be a crime, as I mentioned to you just now, when it affects the public. So it becomes a public wrong, no longer a private wrong. So it becomes a public nuisance. Nuisance is originally a private action, but it can be a public action. It can be a crime when it becomes a public nuisance. Right. So the purpose of tort is basically to protect the legal rights of individuals. So in the case of trespass, for instance, when you are affected by when you got punched by someone, so you want to claim for compensation right, you want to claim for your rights, you claim for compensation to get your rights who become the victim in that situation. In crime, we punish the offender because that's the purpose of the criminal law, to punish. Of course, they have other purpose as well, to rehabilitate, right? But generally, crime is the purpose of criminal law or crime is to punish the offender. In terms of the standard of proof, in torts, like other civil action, it must be proved on the balance of probabilities. So if you have a better case than the defendant, then you can win the case. So balance of probabilities, like 51, 49. If you have slightly better chance, then you have win the case, nah? Yeah. But in the case of criminal or crime, you need to prove your case beyond reasonable doubt, which is higher than that, higher than the in a civil action. So the act below can become tort or crime, where that means it can overlap. Assault or battery. For instance, when someone punch you, you can bring under tort. You can also bring under the tort. You can also bring the case under crime, which is under the penal code. Assault, a criminal assault, is an offence under the penal code. Yeah. Battery also can be a crime under the penal code. So if the case is brought under the crime, then the public prosecutor will initiate the criminal proceeding. But if you take the action under tort, then you yourself need to hire a lawyer to bring the case under tort. Public nuisance, the case of Sungai Kim just now explained to you. Vehicle accident, it can initially start with a tort if it's just a normal regular accident, right? But if it has caused death, the negligent driving can become a culpable homicide that can cause someone to be charged under culpable homicide under section 302 of the penal code. Or breach of statutory duty. So breach of statutory duty here is a case when okay, let's give an example of Majlis Perbandaran, DBKL, for instance. There is a law where DBKL has to cut off the tree regularly to make sure that it does not become sorry, it would not be dangerous or it would not be dangerous or it would not obstruct the road user. So one day, let's say for instance, a PLUS or DBKL failed to do so and has caused accident to the road user. The road user can, if you are affected, either I mean, if you are the only one affected, you can bring under tort, and you can also bring under crime. When you say breach of fiduciary duty, that means you will bring the action according to the provision of the statute. So it can be under tort or under crime, depending on the statute itself. So this one, you will cover this next semester. Plus, normally, like for instance, that's why that they always put on the highway that if you found a foreign object in the middle of the highway, please inform immediately the highway authority, right? Why? Because if anything happen in the highway, then plus has the highway authority will be responsible for any damage. So that is under breach of fiduciary duty. Torts versus contract law. So you are doing contract law as well this semester. So in tort, it's fixed by the law because the principles are based on the common law principle, based on the case laws. Contracts is based on the contract promise between the parties. Whenever there is a breach of contract, so how do we prove a breach of contract? When you can prove the tortfeasor has the intention. In the case of trespass, for instance, because intentional tort, so you have to prove that the tortfeasor has the intention to injure, to cause physical harm, right? Or malicious, like in the case of malicious prosecution just now. Or in the case of negligence and accident, the driver recklessly or negligently drive the car and cause accident. Yeah, this is not breach of contract. This is a breach of law, breach of obligation. In contract, where you have a contract, so you have to what we call it, you have to comply with the contractual obligation. So once you do not comply with the contractual promise of contract or contractual obligation, so that is considered as a breach of law or breach of contract already. Right, in torts, in terms of calculating damages, it is backward looking. This is what we discussed just now. So you claim for compensation as if the tort has never been committed. So you want to restore everything to its original position. But in contract, you sign contract first, right? And then there must be performance in the contract. Then if the party fail to perform the contract, you will refer to the contract. So it's a forward looking, but in tort, it's a backward looking. So you can see the difference here. Contract would not be effective unless it is not performed or performed, right? So it is, you sign a contract first, you get a promise done between the parties. Then if there is any breach, it must be based on the contract between the parties. But for tort, is to restore things in its original position. So what kind of interest protected under tort? It can be economic interest. For instance, in the case of economic loss, I would not have time to describe on this. You can have a look into economic loss. We will discuss on this later under the topic of negligence. Personal liberty or security under the case of trespass to person, or it could be under forced imprisonment in particular, particularly under forced imprisonment. When you got, for instance, locked in a place without your consent. If a police do that under their authority, that's not a problem. But if they restrain or arrest you unnecessarily, they can be charged under forced imprisonment, either under tort or crime. So the same thing, if you are locked in a place where you are not willing to stay there, or you're falsely imprisoned, you can bring the action under trespass. Reputation or dignity, this is very common in the case of defamation. Enjoyment of one's property and land, this is a case of trespass to land. So it's quite a number of interests there. In contract, you're talking about benefit of one's bargain, because you are what we call it, balancing the bargaining power between two parties, right? So if the contract is not fulfilled, then your right as one of the contracting parties will be affected. Either in, when we say bargain here, it's not necessarily financial, it can be non-financial as well. Okay, so that only involve the contracting parties. So interest in torts are more open or are more varied in this situation. Okay, tort versus restitution. Restitution is restitution is a remedy as well under contract and also under the law of trust. So we look into where you can claim for restitution. In tort, it is very exceptional because normally we don't claim for restitution because you have already claimed for compensation. That's why when you go for the law of torts, the main purpose is to claim for compensation. Compensation can be monetary and non-monetary damages. You will learn later towards the end of the semester. But in restitution, this is where someone has unfairly taken advantage of you. For instance, in the case of law of trust, let's say you and other family members have a share over a property, and someone else who has been given trust to take care of the property has misused the property and sold it to a third party. So you can claim under restitution because you have been unjustly enriched, you have been unfairly taken advantage. I mean, the person has unfairly taken advantage of using and selling the property to a third party without the consent of other family members. So that can fall under restitution. That is under trust or can be also under contract. In terms of the remedies, in torts, when there is any breach of obligation, you can return of account for profit. But this, as I mentioned to you just now, okay, imagine a situation where between a person who is entrusted to take care of the property, so he has a fiduciary duty. Okay, fiduciary duty means, let's say the settlor, the owner of the property, and also the beneficiary, the person who will receive the benefit of the property. So then you have the what we call it, the trustee. The trustee is the person who need to take care of the property. So, but the trustee here has problem and has misused the property. So under restitution, as the plaintiff, you can claim for the return money for it and for the losses of money as well. But in torts, return of account for profit, for instance, the example I give you just now under restitution. Or in tort, for instance, in the case of passing off, when someone has used the logo of a company or a logo or trademark of a company and claimed as theirs, for instance, McDonald against Medina, for instance, Medina. So, and they're selling the same product, and the logo is almost the same like McDonald, for instance. So that is considered as a passing off, and you make money out of it, and you claim that you are part of or you are associated with McDonald, and you have attracted people on social media, and McDonald become they have losing the profit, they have losing the customers or clients. In that case, McDonald you bring the claim under passing off. They can claim for the profit that you have gained by using the brand, the trademark, where the public is confused that McDonald and Medina belong to the same company. Same thing like in the case of trespass to land. If the trespass has caused damage to the land, then you can claim for the profit. Or if the land has been sold to a party where there is a structure built on the property, on the land, you can ask for the return of the profit. If they make money out of the property, you can claim for the profit. Or conversion of goods, for instance, for instance, A found a jewellery in Taman Tasik mana kat sini Dataran Nilai lah, for instance, Dataran Nilai, and he knew that the jewellery does not belong, the jewellery belongs to X, for instance, but he sell it to a jewellery shop and make money out of it. He put it on Instagram or whatsoever, so he make money out of it. So once X found out that the jewellery has been sold to a third party, he can claim against the plaintiff that for the profit of the jewellery that has been sold to a third party. So basically, you can get the price and also the differences of the price between the differences between the original and the new price of the jewellery. So that's what we call as account for profit. So you can ask for the profit that has been unfairly gained by the defendant, return for the profit. But of course, you need to, whenever it comes to court, you have to bring up an evidence to provide a convincing case. Okay, torts and equity. Torts is under common law. Equity is under equity is developed under English Court of Chancery. Because of the rigidity of the common law, you may have learned before about the history of common law and equity, so I won't go to that part. So that's different basically in terms of the origin. In terms of the relationship between the parties, in some cases of torts, they rely on what we call as concept of trust, where you have the fiduciary duty. For instance, in negligence, in negligence you have in professional negligence or even medical negligence, you must prove that there is a fiduciary relationship between the parties. Doctor, patient, lawyer, or solicitor, client. So there is a special, or what we call as fiduciary relationship. Fiduciary relationship is based on trust and confidence. So in equity, we have also the concept of fiduciary relationship between the trustee and beneficiary, particularly when it involves division of property, like what I mentioned to you previously. Right? So when it comes to breach of duty, that breach of duty here can, in the case of trust, you can also bring an action under tort. For instance, when the trustee has not administered the property according to the wish of the beneficiaries. For instance, the property is supposed to be, managed or administered in certain way, but the trustee alter or modify the trust or the will according to his own interests. So you can sue as the beneficiary, as the person who received the property. You can sue the trustee under torts for the breach of fiduciary duty. So that is overlap there. Or breach of confidence. Breach of confidence is originally originated from torts. Yeah. For instance, here breach of confidence for misusing private information of a trust, where information of a trust is should be only available to the beneficiary, but it is disclosed by the trustee to a third party without the knowledge of the beneficiary. So this can be a case of breach of trust or fiduciary duty, where the beneficiary can take action against the trustee as well. So in terms of the remedies, there are common law remedies and there are also equitable remedies. So in torts, because it's a common law origin, so actually now there is no difference anymore between common law and equitable remedies. Before, if your case is under common law cause of action, in the ancient history of common law, you can only claim for common law remedies. That means compensation. But now, apart from the compensation, apart from damages, you can also claim for equitable remedies like injunction or account of profits. That means if someone has trespassed your land, you can claim for the damage that the defendant has done upon your land, and you can also apply for injunction to stop the defendant from continuously trespassing the land. If there is any profit gained by the defendant, for instance, he built something and he made profit out of it, you can claim for account of profits. So there is overlap between torts and equity. Many overlaps here, particularly when it comes to the fiduciary duty and also on the remedies. Right, that's all from me today. Unless there is any questions from the class, please feel free to ask. Give you 2-3 minutes. If there is no question, then we shall leave the class and see you next one. Ada soalan? Can you follow the lecture? Am I?
Yes.
Oh, okay. So, yep, so that's all for today. So I guess if there is any questions, please ask.
Doctor,
Yep.
for classification between the differences of tort and others, would
Okay.
we learn in details about the other parts such as equity, restitution? Would we learn in depth or not?
No, because restitution, for restitution, basically you will learn in your law of contract, I think in your second semester under the topic of remedies, and you will cover more detail in the law of trust as well. So for this subject, the remedies that you will learn only on damages. So that shows that the main purpose of the law of torts is to claim for compensation. So you will see later that based on the damage suffered by the plaintiff, what kind of damages you can apply, you can seek to the court. So when I say, as I mentioned to you just now, it can be monetary or non-monetary damages. So to answer your question, for torts, we only focus on damages. On injunction, on the count of profits, you will learn a lot under equity and also, I think, contract as well. Yeah, next semester, if I'm not mistaken. But you can confirm with, I think, Dr. Is it Prof. Alsagov is teaching you contract, right? Yeah.
Yes.
So you can confirm with him. But for torts, we cover only on damages. So we will discuss on the quantum of damages, on how to calculate the damages. A bit of mathematics. You need to have a big skill of mathematics, like calculation skill. Yeah. So we want to answer your question on damages only. Okay, welcome. Any other questions? So I hope that you have the big picture, the overview about what the law of torts is. So when we talk about law of torts, you have, if you look at the course outline, we have, as I mentioned before, we divide it into several sections: intentional torts, unintentional torts, damages, and drafting or pleading. So that's all what you need to do this semester for this subject. Next semester will be quite a number of causes of action, but for this semester, only the cause of action will be trespass and negligence. Of course, there will be subcategory there, but the big category here, the main category will be trespass and negligence. So that's why you need to understand the difference between the two. What you need to prove under trespass, what you need to prove under negligence, and how do you get the damages from the court based on the damage suffered by the plaintiff. And yeah, that's all for this semester. Yeah. So please have a look at your course outline and also your course teaching plan. If you have any questions regarding in understanding the course outline, you can just let me know. Anytime you can text me. You have my number, right? Okay. Okay. Do you have any other questions? No? So I assume there is no question from the class. So thank you so much for the session today. Inshallah, I see you next week. So please have a look at the course material. I will upload the course, the lecture slide after the lecture today. Okay? I dah upload actually. I lupa. I dah upload. Yeah. On goals. Alright, that's all from me. If there is no question, so with that, Assalamualaikum warahmatullahi wabarakatuh.
Thank you, Doctor.
Thank you, Doctor.
Ada.